Welcome to Q2's Demystifying Family Trust webinars. It's great having you with us today. For those of you who have not met me before, my name is Anne Cooper-Smith, and I'm the Director and CEO at Q2 and today's presenter. Q2 Limited are a boutique firm of business strategists and chartered accountants, and we're passionate about helping SME business owners achieve their business and financial goals. Our brand, Q2, refers to Stephen Covey's Quadrant 2, the doing what's important, but not necessarily urgent. Check it out on our website, www.q2.net.nz, if you're not familiar with what Q2 means or our Q2 story. Q2 has a diverse range of clients. Our clients include one-man bands to larger SMEs employing 20 or more staff. We have startup businesses as well as established businesses that have been going for 50 years or more. We also look after the family trust for many of our business clients, and I act as the independent trustee for many of my clients' trusts as well. The thing all our clients have in common is a drive to improve, to make good business and investment decisions, and to protect their wealth and assets. Our services are as diverse as our clients' mix, and we help our clients in a range of different ways. But our most successful clients work with us closely on things such as business planning, problem solving, cash flow improvements, tax planning, business structures, and of course we provide annual accounting and tax services to nearly all our clients, including our trust clients. Before I get started, I just wanted to mention that we do have some capacity to take on new clients at the moment, and we would welcome the opportunity to have a conversation about how we may be able to assist, perhaps you or someone you know who needs expert advice to make good business and investment decisions, to improve profitability and protect their assets. So please get in touch if you'd like to discuss how we may be able to help. A trust can help us protect our assets and provide for our children and grandchildren in the future. Trusts play a very important part in planning ahead, and as Winston Churchill put it, savings are a marvellous thing, especially if your parents did it for you. It's important to plan ahead, and now is a good time to be thinking about your trust. There are questions that we need to be asking ourselves about our trusts, particularly with the new trust legislation that comes into force in January 2021. At this point, I just want to throw in a usual disclaimer that the information in this educational webinar is general in nature and is no substitute for tailored advice that's specific to your particular circumstances. Over the next 40 to 50 minutes, we'll discuss why trusts are so popular in New Zealand and the risks that trusts can protect against. We'll address the impact of the new Trust Act 2019, and we'll look at the issues we've identified during recent trust review work that we've completed for our clients. And finally, we'll look at a few technical issues around memorandum of wishes and powers of attorney. Then we'll cover your next steps and how we can help. So please take plenty of notes today. Some of what we talk about today may sound a little bit like a foreign language, so please send through your questions to us after the webinar if there's anything that you don't fully understand. So for those of you without a trust, you're probably wondering, why should I set up a trust? And for those of you with a family trust already, let's start by going back to when you first set your trust up. Why did you set it up in the first place? With the new trust legislation coming into force, now is a great time to consider whether the reasons you set up the trust are still relevant and if the benefits outweigh the costs of compliance. Indeed, if you don't have a trust, then now is also a great time to think about one, especially with the top tax rate for individuals being set to rise to 39% now that we have a re-elected Labour government. Most likely your trust was set up to protect assets, reduce risk exposure, perhaps to provide some tax savings, and to provide an enduring benefit to yourselves and other family members. So let's look at each of these areas in a little more detail. Asset protection is one of the most common reasons for setting up a trust. Trusts are often used as a place to hold assets such as your family home, your holiday home or batch, investment portfolios, and other high-value assets. By transferring your personal assets to the trust, they can be protected against certain risks, which we will cover shortly. A trust can also be used as a vehicle to own the shares in your business activity, which is usually in a limited liability company, and to hold life insurance policies so that in the event of your death, the proceeds of the insurance will go directly to the trust. The risks that you're trying to mitigate often relate to being in business. There are risks around HR, health and safety, and commercial risks, such as the ability to pay creditors, the bank, and the IRD. Even if your business is a limited liability company, there are circumstances where you may be held personally liable as a director, and that could put your personal assets at risk. Trusts are also useful to protect against relationship property claims or poor financial management by the next generation. If you die and leave your assets to your children and then they divorce or separate from their partners, it's quite possible that 50% of the inheritance that you left them could go to your child's spouse or partner. A trust can help protect against that situation arising. Equally, a trust could be a way of reducing exposure to the government. In the past, trusts were used to access rest home care subsidies. However, new rules make this almost impossible to claim now if you have assets in a trust. And while we don't currently have a state duty, capital gains tax as such, or wealth taxes in New Zealand, a trust may be a way of reducing exposure to these if they were to be implemented in the future. So the questions to ask yourself now should be, are my assets needing to be protected? And am I or my family still exposed to those same areas of risk? For example, if you no longer have a business activity because you've sold your business and have no bank debt, you are likely not to be exposed to creditor or bank risk, so you may not need your trust for those reasons. But on the flip side, the benefits of asset protection from relationship property claims or beneficiaries who may have poor financial management skills may still mean that your trust is of value to you and your children and your grandchildren. We have to think about whether these risks are still in place and whether it's still appropriate to have your trust. Assuming the trust is still valid, a trust review will help identify any issues that need to be addressed to ensure that your trust offers sufficient asset protection and risk mitigation. And for those of you without a trust, you need to consider what risks you have and how a trust could protect against those risks. I want to point out here that I do not recommend setting up a trust solely for tax savings reasons. Tax laws change all the time, especially when there's change in government, whereas a trust is a long-term ownership structure that may stay in place for 80 years or even up to 125 years after the new legislation comes into play. Having said that, there may be tax savings that can be made by using a trust. Trust income is generally or currently taxed at 33%, while beneficiaries will pay their personal tax on any income distributed to the beneficiary from the trust. This means that if a beneficiary's tax rate is lower than 33%, then incidental tax savings can be made by allocating trust income to those beneficiaries. It also means that if tax rates for individuals increase as expected to 39% for those earning over $180,000, then tax may be saved by having investment income in a trust rather than being owned personally. And one of the reasons I like trusts for tax planning is the increased flexibility that it gives us. And it's important to note that if the only reason that you're using a trust is to access tax benefits, then your trust may not pass the scrutiny of the IRD. The tax savings should be incidental to the other benefits of having your trust and not the main reason for having it. From a tax perspective, There should always be what we call a commercial reality for the structuring decisions that are made. If you set your trust up to provide enduring value to family members, you need to think about the next generation and what their expectations are. You perhaps need to consider questions such as, are the beneficiaries old enough to manage assets if they were being transferred to them now? And are the beneficiaries financially mature? Could they be exposed to relationship property claims? And do you want to ensure that future generations, such as your grandchildren and great-grandchildren, are provided for? A trust has the advantage that assets don't need to be transferred immediately upon your death. They can be held in trust to be distributed in a way that may preserve the capital for the longer term and protect assets until beneficiaries are old enough and financially mature enough to manage them properly. Also, holding assets in a trust can be a great way to protect assets from relationship property claims, as trust assets don't become intermingled with property, as they would otherwise happen if they were distributed to the beneficiaries. In order to really understand what a trust is all about, we need to look at some of the terminology that we use. The first one is a settler, and it's a settler that sets up the trust and typically transfers property into the trust, providing that value over time or perhaps in one lump sum. For example, Mum and Dad may be the settlers of the trust because they transferred their family home into the trust at market value with an on-demand debt or loan owed back to them by the trust. That debt would have most likely been recorded as a deed of debt, which was then gifted away over several years. When the gifting rules changed in 2011, the debt may have been forgiven in full, or it may have been extinguished upon the death of Mum and Dad by way of their will. The trustees are the people who are charged with looking after those assets for the benefit of the beneficiaries. Often Mum and Dad are trustees as well as settlers, along with a third person such as a professional or independent trustee. And as I mentioned earlier, I act as independent trustee for a number of Q2 clients. And the beneficiaries are the people or organisations that the trust assets are being held on behalf of, and they usually include Mum and Dad, their children and grandchildren. Beneficiaries can also include other family members, friends, charities, or trusts that have been set up for the benefit of beneficiaries. A trust for the benefit of beneficiaries allows the assets from one trust to be transferred to new trusts. So, for example, the assets from Mum and Dad's trust can be transferred to new trusts, and one new trust could be set up for each of the children who are beneficiaries. The last class of people to consider are what we call the appointors, and these are the people who have the power to appoint and remove trustees and beneficiaries. A useful way to remember the types of people referred to on this slide is to think about the origins of trusts, which actually date right back to the Crusades in the 12th century in Britain. During the Crusades, the knights would transfer their land to the monks of the local church to hold, so that if the knights were killed in battle, the land was still available for use by the families of the knights. So in this example, the knights were the settlers who passed their land over to the monks, who acted as trustees, and the monks held the land for the benefit of the wives and children of the knights. If you undertake a trust review with us, we'll help determine whether the trustees are still the right people and the beneficiary classes are still correct, and that the appointors are still able and willing to act and are comfortable with responsibilities that they are assigned. Being able and willing to act is even more important given the requirements of the Trust Act 2019. We must also think about what happens if one of the trustees or appointers dies. Who will those powers be transferred to? These are the technical issues that you need to be thinking about, and this can all be done as part of a trust review. The trust deed is a document that sets out the terms of your trust. You must ensure that those terms comply with the new legislation. Your trust deed appoints the trustees who will look after the trust assets until the trust is wound up. There are certain duties that the trustees must abide by under the new Act, and others which may be amended by the trust deed. We'll look at those duties shortly, but it's important that you reviewed the duties and have decided whether any default duties should be amended by the trust deed. The trust deed is also where the beneficiaries are identified. These beneficiaries can be specifically named in the deed, for example, John and Jane, or the wording can be wide enough to include all children, grandchildren, and great-grandchildren to cover anyone who may not even be born when the trust is set up. The trust deed also allocates the power to appoint beneficiaries and trustees. It's important that the trust deed is clear as to who has these powers and how they can be used. And finally, the trust deed will set the vesting date for the trust. This is the date upon which the trust will be wound up, and the trustees will no longer hold the assets. Previously, trusts had a maximum life of 80 years under the old legislation. However, the new Trust Act 2019 allows for trusts to stay in place for up to 125 years. It's important that your trust deed is clear on this date and what will happen to the assets of the trust on the final vesting date. There are some common issues that come up with trust deeds which we often pick up during a trust review. If your trust is relatively old, it's likely to be less flexible than a more modern trust. This could mean that you're unable to make the changes to your trust that you'd like to make, such as changing the vesting date or adding grandchildren as beneficiaries. If this is the case, does the trust deed allow the trust to be resettled into a new trust? It's important to note that resettlement must be for the benefit or advancement of one or more of the beneficiaries of the existing trust. Issues may arise with who has the power to add beneficiaries. If both mum and dad have the power to add beneficiaries and then one of them dies, should the other retain this power? For example, what happens if the surviving parent forms a new relationship with somebody who has children? Is it okay for him or her to add those other children as beneficiaries to the trust? Or what happens if the surviving parent has a falling out with one of the children? Should they be able to remove that child as a beneficiary of the trust? There are no right or wrong answers here, but these things do need to be considered and recorded in the trust deed. Another issue that we sometimes come across is the beneficiary classes not being wide enough, which may lead to a situation where the trust needs to be wound up, but the beneficiaries aren't clearly defined, or there aren't any surviving beneficiaries. The opposite can also be the case, where the class of beneficiaries is too wide, and for practical reasons it needs to be reduced. And this may be especially the case now that trustees are expected to make disclosure to the trust beneficiaries. And lastly, you need to think about who has the power to appoint trustees after you die, either to replace you as trustee or where an existing trustee may be unable or unwilling to act. So as you can see, there's a lot of things that your trust deed needs to cover, and some of these things you may never even have thought of or considered. It's important that you take the time to review your trust deed and to ensure that it represents your true intentions for your trust. It's important that the beneficiaries are clearly identifiable, and there are two classes of beneficiary, what we call discretionary beneficiaries and final beneficiaries. So discretionary beneficiaries can only benefit from the trust assets at the discretion of the trustees, whereas the final beneficiaries will benefit upon the wind-up of the trust on vesting day. One thing is to consider is whether the beneficiaries of your trust are still appropriate. Maybe you set up your trust before you decided to have children, Or perhaps you're no longer close to a particular sibling who is listed as a beneficiary. So it's important to review your beneficiaries and make sure that they are still appropriate. And another thing to consider is how beneficiary loan accounts are to be treated. These may arise when you have transferred income to some beneficiaries, possibly to access tax benefits, but haven't yet paid these out in cash. Or you may have paid out cash to some beneficiaries, but not to others. So let's take an example. Let's say your daughter attended university while your son moved straight to employment from school. So you may have allocated income from your trust to your daughter while she was at university, as her marginal tax rate was probably much lower. But you didn't do this before your son because he was earning income already. So in this example, it's possible that your daughter may have a large balance of funds technically owed to her, and your son may be owed nothing from the trust. So you need to consider how these different loan balances are to be treated. On a similar vein, large balances owed to trusts can build up sometimes in trading companies. And this happens where the profits are credited as dividends to the trust, but not actually paid out in cash. In this instance, it's a great idea to have security in place so that if the company gets into financial difficulty, the trust is a secured creditor with the ability to be repaid before unsecured creditors. And of course, the best time to put those securities in place is when the company is trading profitably. And lastly, especially in the current economic climate, it's important to review the investments that the trust has made to date. It may be that the strategies adopted in the past are no longer appropriate, or that you have other investments that may sit better either in the trust or in other entities. So all of these issues need to be considered as they relate to your personal situation. On top of any issues needing the attention in your trust documentation, there's also the new legislation to consider. I'm sure you're all aware that gift duty was abolished back in 2011, as I mentioned earlier, but some of you may still have the same annual gifting of $27,000 per year per person in place. It's important to review your gifting program and make sure it's appropriate given the legislation changes. And the Trust Act 2019 replaces the Trust Administration Act 1956, and it codifies a lot of what existed previously only in case law. There are an estimated 300,000 to 500,000 trusts in New Zealand, so the new legislation will have a big impact. And the new legislation comes into force on the 30th of January 2021. However, this is a date that your trust needs to be compliant by, so start reviewing your trust now to ensure compliance. Let's run through a few of the key changes to the legislation which you need to be aware of and to understand the impact that they may have on your trust. A lot of these trustees' duties already existed under case law, but the 2019 Trust Act now clarifies exactly what the expectations are, and you must ensure that, as a trustee, you're complying with these duties. The Act specifies two types of duties: mandatory duties and default duties. The mandatory duties apply regardless of what the trust deed says, whereas the default duties may apply unless they're modified or excluded by the trust deed. So let's take a quick look at those duties. Mandatory duties are the duties that cannot be contracted out of by using the trust deed. So they apply regardless of what the trust deed says. And those duties include things such as the trustees knowing the terms of the trust, acting in accordance with those terms, acting honestly and in good faith, and acting for the benefit of beneficiaries or to further the permitted purpose of the trust, and to exercise powers for proper purpose. On the other hand, the default duties specified in the 2019 Trust Act must be performed unless modified or excluded by the trust deed. Most of them are best practice and should be performed. However, Some are commonly modified. Acting with a duty of care and investing prudently and not exercising power for the trustee's own benefit should really go without saying. And to actively and regularly consider the exercise of trust powers highlights the importance of holding regular meetings and recording evidence of those meetings. And not committing trustees to future exercises of discretion means that as a trustee you can't force income or capital to be allocated in a certain way in the future, for example, for one beneficiary over another. And avoiding conflicts of interest sounds obvious, but it's important that decisions are documented. This is particularly so where there is a potential for conflict of interest. This is often the case where the settlers are also the trustees and beneficiaries. The duty to act impartially doesn't mean that trustees must distribute trust assets equally between the beneficiaries, but that they must act impartially in the management of those trust assets. And the duty to not profit from the trusteeship and to act for no reward may need to be modified where trustees are being paid. And lastly, the duty to act unanimously. It is important to document decisions to prove that they were made unanimously if this duty isn't modified by the trustee. The 2019 Trust Act has introduced requirements for beneficiaries to access certain trust information. This is to ensure that beneficiaries have enough information to enable the terms of the trust and to enforce the trustee's duties against the trustees. Now, there is a presumption that trustees must notify all beneficiaries of basic trust information. This basic trust information includes the fact that a person is a beneficiary of the trust and the name and contact details of the trustees, the occurrence of and details of each appointment, removal, retirement of a trustee as it occurs, and also the right of the beneficiary to request a copy of the terms of the trust or further trust information. This is a significant change, as previously trustees didn't need to inform beneficiaries that they were beneficiaries of the trust. There's also a presumption that the trustee gives other information, such as the terms of the trust and information about the administration of the trust and trust property, to beneficiaries upon request. But note that this doesn't include the reasons for the trustees making particular decisions. Each of these presumptions won't apply if the trustee reasonably considers that the information should not be provided, taking into account certain factors such as the nature of the interest held, whether the information is subject to personal or commercial confidentiality, the expectations of the settler at the time of the trust's creation as to whether that information would be given, the age and circumstances of the beneficiaries, and the effect on the beneficiary of giving the information requested, the effect on trustees, other beneficiaries, and perhaps third parties of giving the information, and also the practicality of providing the information and safeguarding that information. So as you can see, there are plenty of valid reasons why the trustee may decide not to release certain information to beneficiaries. There are other significant changes that you also should be aware of. And as I've already mentioned, the maximum duration of a trust has increased from 80 years to 125 years. Now, many people will think that 80 years is more than adequate, but if you want to increase the vesting date, you may want to increase the vesting date if you want your trust to benefit your grandchildren and perhaps great-grandchildren. And the age of being deemed an adult is now stated as 18 years of age. The trustee must not limit or exclude a trustee's liability, nor indemnify trustees for dishonesty, wilful misconduct, or negligence. And the Act also stipulates an alternate dispute resolution process, such as mediation, which is set out in the Act. And this also covers disputes between trustees. and the courts have been given wide powers to review acts, omissions, and the decisions of trustees. Under the old legislation, there was no clarity about what trust records needed to be kept. But under the Trust Act 2019, trustees must keep a copy of the core documents relating to the trust. And if there's more than one trustee, each trustee must keep their own copy of the trust deed and a record of the variations to that deed. One trustee must keep the other required documents, which must be made available to the other trustees on request. At Q2, we keep an electronic minute book for the trust that we administer. So in effect, we are handling the retention of core documents on behalf of our trustees. And when a trusteeship ends, the trustee must pass on the documents that they were holding to another trustee. And you can see from the slide that the list of core documents is quite extensive. And all these records must be kept. Now, it's best practice for settlers to produce what we call a memorandum of wishes. A memorandum of wishes is a little bit like your will, but it's for your trust, and it's not actually binding on your trustees, but it does state what you would like to have happen to your assets in the trust once you've passed away or are no longer acting as trustee. It's important that you keep this document up to date to avoid potential dispute and to provide future direction to your trustees. If you created your memorandum of wishes 20 years ago, or even 30 years ago, it may no longer be appropriate, nor reflect your current thinking. So it's important that you review it and keep it up to date. What do you want to have happen to your trust when you die? Should it be wound up, or should it continue? This should be set out in your memorandum of wishes. Your memorandum of wishes should also state how you want the beneficiaries to be treated. So, for example, in the earlier example, a daughter had gone to university and may have used trust fund to pay the fees while the son went straight to work. So, should the son receive more when the trust is wound up to make up for the money that the daughter received earlier? Or was the money given on a use it or lose it basis? So there should be no adjustment made to bring the two amounts into equality. Likewise, do you want to keep some of the trust funds set aside until your children have reached financial maturity? There are no right answers here. Each trust and each family situation will be different. What's important is to get the documentation right so that it reflects your intention, and that's something we can help you with as part of our trust review process. We've also got to think about choosing powers of attorneys. Now, there's two main types of powers of attorneys. The first one is a general power of attorney, and the second one is an enduring power of attorney. A general power of attorney is temporary and could be used to allow someone else to manage your affairs, for example, while you're overseas. And this general power of attorney ceases to be valid when you no longer have the capability or capacity to instruct the attorney. On the other hand, enduring powers of attorneys let you decide who can make important decisions about you if you are unable to do so due to an accident or illness. And it's important that you appoint your powers of attorneys while you have the capacity to choose who you want to have act on your behalf. And there are two types of enduring powers of attorneys. The first one is power of attorney for your financial affairs and property, which basically is somebody who signs on your behalf. And the other one is for your personal care and welfare, which basically means somebody who will make decisions about your health when you're no longer able to do so. You may have appointed people in the past that are no longer appropriate, maybe because they're no longer alive or you're no longer close to them. So we must consider the need to have the power of attorneys in place and be sure that people are familiar with the responsibilities that they have in this role and that they are willing and able to act. Other things to think about in terms of the validity of the trust and the need for it include your wills. Do you have a will, and have you reviewed it recently? It might be out of date and therefore no longer consistent with your trust deed. So, for example, you may have specified in your trust deed that the power to add or remove beneficiaries is to be transferred to somebody you've specified in your will, but your will might not actually specify who that person is. Or you may not have specified in your will what you want to happen to the debts owed to you by your trust. Perhaps you want to forgive all debt owed to you by the trust, or maybe it will be advantageous to transfer that debt to your spouse. I also recommend that your will include your preference for your funeral arrangements. Do you want to be buried or cremated? And what do you want done with your ashes? Clarity around these sorts of issues helps your loved ones through what is normally a very difficult time, and sometimes your family have very different thoughts and conflicting ideas about what your funeral arrangements should be. If you have young children, your will could also include who should have the guardianship of those children if both you and your spouse were to die. And if you don't have a will at all, this could cause serious hardship and unfairness should you die, as the law dictates who will get what assets, and the law may not reflect what you would actually want to have happen. For example, if someone dies who is in a relationship and whose parents are alive but has no children, then the spouse of the partner is entitled to the personal chattels plus $155,000 and 2/3 of anything else that is left, while the parents receive the remaining 1/3. However, if someone dies with a partner and children, then the partner will receive the personal chattels plus $155,000 and 1/3 of anything that is left, while the children receive the remaining 2/3. Also, if you die without a will, your assets are likely to be frozen for quite a period of time until things are sorted out, and the cost to administer your estate will be much higher than necessary. And this could cause serious financial hardship to your spouse or partner or children. So please make sure that you have a will and that it reflects your current wishes and also considers the terms of your trust deed. Another area of risk is your personal assets. Do you have personal assets outside of the trust that should be moved into the trust? This is particularly important if you're in business or have acquired significant assets since the formation of the trust. Be aware that if your family home is owned by the trust, then any capital improvements that you pay for personally will remain your personal asset unless they are documented and gifted to the trust. And this is something that we consider and document when we undertake annual trust reviews for our clients. Another area of risk is your business trusts. Have you got the most appropriate structure for asset protection and tax planning benefits? So, for example, if you're considering winding up your trust, do you need a different entity such as a company to hold any of the assets currently in the trust? I have previously mentioned tax planning and that decisions around which assets should be held in different entities, such as companies and trusts, and settlers gifting decisions, they should all consider the tax implications or benefits. Once a decision has been implemented, it's often really difficult or almost impossible to reverse a poorly thought out strategy without some very negative tax consequences. So for this reason, please consult with your accountant before making a trust or structuring decisions. These are all assets that we can discuss as part of the trust review to make sure that your trust mitigates as much risk as possible. So, what are your next steps from here? As we always say, doing nothing is not an option. So you need to make a clear plan and consider how you ensure that your trust remains compliant with the new Act, and whether you still need a trust, and if not, what steps you need to take to wind it up. Or if you don't have a trust at all, consider whether you need one and take some advice around that. And remember, we're here to help you and we want to help. The information in this educational webinar is general in nature and it's no substitute for specific tailored advice and support. There are several ways that we can help you, however, specifically beyond today's webinar. So the main question you need to ask are, do I need a trust or do I still need my trust? And who are the right people to ensure that it continues providing the benefits that I want and need? And answering these questions properly will ensure that your trust remains compliant. There are several ways that Q2 can help you with this. A trust review will give you clarity as to whether you still need your trust and how you can be sure it complies with the Trust Act 2019. If we look after your trust administration, we'll maintain your trust records in accordance with the Trust Act 2019 and make sure that all trustees have access to the information in one secure place. If you would like us to act or continue to act as your professional trustee, we are happy to do so. Many professionals are shying away from the service in light of the requirements of the new legislation. So if you use someone else as a professional trustee, check in with them to make sure that they'll continue offering you this service. And if you're not sure if you need a full trust review, we can send you a complimentary How Robust is Your Trust checklist, which will help identify potential areas of concern and help you determine the actions that you should take to ensure your trust is compliant. We also have a really useful guide to family trusts that you can keep and refer back to. And finally, we also offer client and prospective clients an annual 1-hour complimentary meeting. Doing nothing is potentially a risky strategy, and having some type of review is going to give you greater confidence in your unique situation. So if you have any questions as a result of this webinar, please submit them to us, either in the chat panel or on the exit survey or by way of email after the webinar. We will answer all questions confidentially afterwards. Before we go, I thought I'd share Benjamin Franklin's quote with you, and he says, "An ounce of prevention is worth a pound of cure." So make a simple plan today, write down your next steps, give each of them an owner and a completion date, and remember, if you need our support, we're here for you. This is our last webinar for 2020, as next month we'll be running a live half-day training session called Quick Start to Financial Intelligence. This half-day training is for business owners and it follows on from our Know Your Numbers webinar that we ran last month. If you missed that webinar, you can watch it on our website www.q2.net.nz/webinars. And if you'd like more information about our Quick Start to Financial Intelligence half-day training, mark your interest on the exit survey and we'll send you some more information. There are only limited places and it's of great value, so don't miss out. So thanks for making the time to attend this webinar. We appreciate that your time is really valuable, and please do complete the brief exit survey following the session so that we continuously improve and get your feedback on how we may be able to assist you. We hope to have given you plenty of things to ponder today and some clear next steps for you and your trust. So that's all from me today. Have a great day. Bye.